Good morning. This is the audio review of intentional torts and product liability. Intentional torts are still within the tort family of law, where somebody did something to another person. It's different than negligence. Negligence is based in this idea that you have a responsibility to protect someone else from unreasonable risk of harm. Here, an intentional tort is wrongful and is knowingly committed. I intended to create the outcome of the act, or I knew with substantial certainty that an outcome would react. We'll look at harm to persons, which could be battery or assault or defamation, false imprisonment, the intentional infliction of emotional distress, the invasion of the right to privacy. Could be harm to property like trespass or trespass to personal property or disparagement of property. Many of these intentional torts are similar to criminal acts. As we looked at perhaps a decade or so ago, the O.J. Simpson the O.J. Simpson murder claims. He was found innocent or not guilty on the claim of murder, yet he was liable for the act under a civil claim, under an intentional tort claim. So here we're looking at harm to person and harm to property. It's wrongful and knowingly committed. I intended that outcome or knew with substantial certainty that that outcome would react. And this is still underneath the civil lawsuit standard of proof that's 51% preponderance of the evidence. The elements of a battery is an intentional, harmful, or offensive touching of another that is unprivileged and unpermitted. The elements are intent to contact, harmful or offensive touching, unprivileged, unpermitted, and involves damages. For instance, if you are a recreational therapist and you are performing some sort of action on a client that is harmful or offensive to them, if they did not consent to it, if it's not privileged, unpermitted, then damages may occur. Intentional, harmful, or offensive touching. It could be considered let me go back for a second. The elements of assault. This could be considered a fight. If I harm somebody in a fight, intentional, harmful, offensive touching. Elements of assault is that threat of a battery. The battery is the harmful, offensive touching. Assault is the threat of it. So for this, you need an intent. You need to cause apprehension of immediate battery, the harmful or offensive touching, the apparent ability to move forward with that, and the damages. There's a couple of good videos that I put on here for assault at the bottom, the YouTube, that actually works with a baseball example with a couple of guys jumped from the stands and attacked a baseball coach. Certainly there was battery because there was harmful and offensive touching. If he was not aware that the people were coming at him, then there would be no assault charge. We can discuss Hackbart versus Cincinnati Bengals when we talk about an offensive battery, offensive touching that occurred outside the regulation of football. So it was not inherent, it was something additional. Kaufman versus Garnett, another case that we'll look at where a youth football player and a coach during trying to show them the ability to tackle caused harm. Was he privileged? Did he consent to that type of activity? Coomer versus Kansas City Royals, a case where a patron went to a Kansas City Royals baseball game and got hit in the eye with a flying hot dog. They had one of those hot dog guns on the field, shooting it into the stands. He was looking out the other direction, hit him in the head, actually caused significant harm to his eye. Are the Kansas City Royals, and in fact the person inside the mascot outfit, are they liable for those injuries? Stringer versus the Minnesota Vikings we can look at in terms of a offensive player who was overheated during a summer practice and he had some medical attention, perhaps not enough from the Minnesota Vikings, went to a hospital to try to cool down, and in fact slipped into a coma and ended up dying. Another type of intentional tort that we can look at is defamation. Defamation, the elements of it is a false and defamatory statement published to a third party that harms the reputation of the person defamed and causes injuries and results in damages. Those injuries can be injury to reputation. It could cost you future business and employment. It's a false and defamatory statement published to a third party or spoken or told to a third party that harms the reputation. Libel is written defamation, something written on the internet, something written in magazine or newspapers. Slander is oral defamation. Defenses to defamation. If you are accused of defaming somebody or committing libel or slander, the truth is always a defense. It wasn't a false comment. The person actually possesses that trait. Or privilege. Public figures must show actual malice, knowledge of falsity or reckless disregard for the truth, as well as falsity and damages. Meaning, if you are a public figure, if you are first a public official, if you're a governmental official, then if you're a public figure, a couple of cases came out, a celebrity or somebody well known, and then it extended to people who are well known because of some sort of situation. Those type of people who have a lot of media attention to them, somebody who is well known, not only has to show actual malice, that the person who committed the defamation, the libel, or the slander actually did it knowing that the information was false, or reckless disregard for the truth, where it may not have been investigated, is this true or not? The reason why this standard is higher than an average citizen is the fact that the higher media attention and the fact that you're public, you're able to better combat that outside of a courtroom. You're able to gather a group of people, say, this is in fact false. Also, we have a higher standard, especially when it comes to governmental officials, because this is really the crux of our First Amendment, that people should not feel inhibited to make claims against government or government officials for fear of being sued for defamation. Intentional tort of false imprisonment, the intent to confine another within a particular area against the will of the person confined. Actual has confinement, act caused the confinement, as well as person is aware of their confinement and is harmed. We see this in a retail environment with somebody shoplifting. We saw this claim a few years ago where a player, the coach thought he had a concussion. The player didn't really think he did, and the coach put him in a shed. And the shed, the coach claimed, was cool and dark and better for the player who was exhibiting some symptoms of concussion. The coach claimed that it was never locked and he had freedom to go in and out. The player claimed false imprisonment, said that he was sent to this area, he was locked in this, and he was basically imprisoned in this area without his consent. Another intentional tort, infliction of emotional distress. The act represents extreme and outrageous conduct that results in severe emotional distress. Has to be an intentional act, has to be extreme or outrageous conduct causing severe stress. These damages are emotional, not physical. So for an emotional distress, we're talking about, even though it's harming somebody's emotional well-being, the standard that needs to be met is very high. It's not just saying something mean about somebody. It is an extreme or outrageous conduct. We can see a lot of this now in the bullying discussion, certainly online bullying. That there was a case in 2015 where I think online messages were between a girlfriend and a boyfriend, where the female actually encouraged him and challenged him to commit suicide, where in fact he did commit suicide. And I think the family was looking at an infliction of emotional distress claim because it was an intentional act that the girl did, and they were able to see a lot of these messages and emails and postings. It certainly was extreme and outrageous to try to challenge somebody to kill themselves, which caused severe emotional distress, not just for the person that ended up committing suicide, but for the family to go through this horrific aspect of their loved one going through that. Casillas versus Walled Lake talks about a lot of these issues and what in fact is emotional distress and what isn't. We have a right to privacy. A private citizen has a right in his or her life to be private. And it comes into 4 specific areas. You have a right to control your name and likeness, that it's not used for commercial purposes in many different areas. You have a right to prohibit people from intruding into your private life. You have a right not to have people, which is called false light, not showing you or saying lies about you or creating some sort of negative persona to you. There's also right to privacy, public disclosure of private facts. We saw this just recently with perhaps the media giving out private information, maybe private medical information that a player or a person may not want disclosed to the public. Appropriation occurs when someone uses, without your permission or your benefit, your name, likeness, or other identifying characteristics. In a public area, this is a right to publicity, that you control your name, your likeness. Michael Jordan just had a lawsuit and is going through another lawsuit. People congratulating him, commercial entities congratulating him on his Hall of Fame induction, using his name for an advertisement or poster. People have the right to control their images for commercial purposes. There are some defenses. The person consented to this. There's also First Amendment freedom of speech defenses allowed. You're allowed to comment on other people if it's newsworthy or if you have some sort of artistic change to it. At times, you're allowed to defend against a right to publicity claim. Invasion of privacy, the intrusion, is a civil claim, not criminal. When someone invades your home or searches your belongings without your permission, this could be highly offensive. Defense here is consent. Perhaps search and seizures, perhaps drug testing, not done in a certain way. A civil lawsuit more than a criminal, thus giving you compensatory damages. This is the claim that you would make. Again, a lot of these intentional tort claims are very similar to criminal claims. Just criminal, the state or the government is bringing the claim. Here it's person to person in order to get compensatory damages. Disparagement of property, untrue statement about your product. It could be slander of quality. Your shoes aren't that good if you're a manufacturer of shoes, or say negative things about a ski slope or fitness center or your recreational therapy clinic. You can slander quality. You can slander title. So untrue statements about product or property that results in economic loss. You have to prove that the slander, that the disparagement of the property resulted in economic loss. Product liability is liability for harm caused by a consumer product. We're going to affix that liability to the manufacturer and the distributor. It's based on legal theories in tort and in contract law. In tort, it's negligence, and strict liability. In contracts, it's warranties, whether it's express or implied. Here we're looking at this idea: if a consumer is harmed by a product that is improperly made, we're going to hold the manufacturer and distributors of that product liable for those injuries. Just repeat of negligence: duty, breach, standard, harm, standard care, breach of that standard, causation, and damages. Traditionally, it's difficult for plaintiffs to prove that manufacturers acted unreasonably in the creation or sale of the product. So product liability shows it doesn't matter if you unreasonably care that this product was defective. The fact that the product was defective shows that you didn't act in a certain way. It's liability without fault. You're saying that the product was defective in design, manufacture, or warning when it was sold. Either the entire design was defective, so every product caused an unreasonable risk of harm. It was defective in manufacture. This specific product, this one item, went through your process and became unreasonably risky of harm, or there was no warning that should have warned people about this. The defendant is in the business of selling such products, so they should have some sort of expertise in it. The product is unreasonably dangerous because of that defect. Plaintiff is injured by the product. Defective condition is the proximate cause of the injury, and the product was not substantially modified since the time of sale. So if the product was modified by the end user or by someone else, and injury occurred, product liability may not be held. Strict liability is a part of this. We're going to hold that person strictly liable. In a sport context, strict liability, another example would be that if you test positive for performance enhancing drugs, the strict liability is you participated with that. We're going to hold you responsible. We're going to, bar you from that competition, and we may punish you for the future. We don't need to know or find out, was it a mistake? Did somebody slip you something? Was your doctor at fault? It doesn't matter who was at fault. You participated with a performance enhancing drug. It's your responsibility to keep yourself away from that material, yet it happened. Therefore, here's the punishment. What is a defect? Central to the definition of this strict product liability, a defect design makes the product unreasonably dangerous. A design defects makes the product, even if it's not done with fault. There's a manufacturer defect that one item makes it unreasonably dangerous, and the warning must be reasonable for the defect and must deal with foreseeable misuse. Defenses in strict liability: contributory negligence, assumption of risk, and foreseeable misuse. Here's just an example again of the types of defects. Manufacturing defects: the product is manufactured, individual product is made wrong. A design defects: the product line is made incorrectly. In that aspect, there's a risk utility. Could there be an alternative approach made to make the product safer? Could we have done something different? Could we have made the skis safer? Could we have had a backup parachute come out? Could we have done something different to make that product less dangerous? There's a duty to warn of inherent dangers. If there's no warning, then strict liability may attach, and a duty to warn of foreseeable misuse. If we foresee people using this product in a way that it wasn't intended, we need to warn people of that. For instance, we see a lot of toy football helmets being sold, and the warning in there is foreseeable to use this football helmet actually playing football. It's foreseeable to see a toy helmet bought at a retail store be used in a actual game. These toy helmets are not fitted properly. Their pounds per square inch protection isn't at an acceptable level, yet it's foreseeable that somebody would do that, so we need to warn of that misuse. Case: Traub versus Cornell University, where a player is playing recreational basketball on a basket. Criminal law: it's very rare that criminal charges get filed during athletic competition. It's becoming more common in participatory or grassroots events. Reason why we don't have a lot of crime coming out of participation: there's assumption of risk. We kind of assume the risk that there's going to be some sort of activity. You have to have an intent to commit that crime. Oftentimes we don't have that intent ability to us. It's not really a high priority for prosecutors to bring charges against other people within a sport. Perhaps we saw most recently, high profile, was the Tony Stewart criminal claims where he hit the guy in the dirt track and caused that person to die. He was found not able to fulfill criminal charges. The prosecutor didn't see a crime there, wasn't able to generate enough intent to show that he meant to kill that person. It's not a high priority. They have other things to do. It's also difficult to win elections if you're prosecuting local sports stars. Oftentimes becoming an assistant district attorney or mayor involves very high popularity, and you're not going to get that if you're prosecuting sports stars within the sport itself. This is not criminal law for a sports star doing something outside of it. It's not Ray Rice facing criminal charges for spousal abuse or assault against his girlfriend, fiance at that point. This is within the sport itself. Also, leagues typically punish players for outrageous activity through fines or suspensions. Um, so a lot of prosecutors will look at and see a person is punished, they lost a lot of money, they're not able to participate in their event, and may see that that may be punishment enough. For example, hockey with a lot of stick work and hitting people with the stick in the gut, in the head. If that's done on the city street, that's certainly a criminal offense. On the ice, most prosecutors allow it. There's been a couple of prosecutions, especially in Canada, where somebody's taken the stick and deliberately hit somebody over top of the head, where we'd see that being a crime to commit that type of injury. However, most prosecutors tend to allow the leagues to punish those players. Regina Green is an example of a hockey situation using the stick as a weapon. State versus Guldoji, and I always mispronounce that, I apologize, is a criminal action where players are doing pickup basketball or intramural basketball, and there's a crime that may have been committed in that aspect. Again, participatory grassroots, we can see some criminal laws becoming more prevalent because we don't really have that league structure or that high fines and punishment. We see a separate way of creating a modifying of behaviors. For example, on here as well, you have state versus the defendant. The state brings the charges. It's not a civil action. I hope intentional torts and criminal law are a little bit clearer now. Thank you.